Some lawyers, like me in the past, take depositions to learn the case. Others take them to win the case. That latter technique is what we are here about today. I'm Rob Schenk, a nursing home lawyer, and this week I'm joined by legendary trial attorney Roger Dodd to discuss cross-examination during depositions and why it leads to stronger, cleaner testimony. It all boils down to essentially what Ike used to say, that planning is essential, but plans are useless. And that's Dwight Eisenhower. That's not Ike Turner. Stick around. Gene, I still feel like it's not the intro jingle. It still sounds like a truck commercial. So maybe we can really try to change it around a little bit for next week. Folks, I'm excited today about today's episode. And the people working on the house next to me are also super excited as well. But as I mentioned at the top, we are having a conversation with Roger Dodd about cross-examination. And one of the reasons why I wanted to have him on is because he has written an updated 4th edition of the Science of Cross-Examination book, which I have the 2nd edition. I thought I had the 3rd edition, but I have the 2nd edition. All the editions have the seal of approval, but if you're interested in what we talk about today, definitely get that new edition. According to Roger, it's gonna be the best one. If you want homework for this episode, I recommend that you go back and listen to a few episodes. First, you can go back to episode 224, which we had Roger on the first time. This is way back in May of 2024. So it's been 2 years just about talking about cross-examination depositions, where we kind of talk about from a 40,000 foot view. We also talked in episode 222 with Kate Hughes, deposition strategies that's more specific to nursing homes, as well as in episode 242 with attorney Don Smith. Great nursing home specific episodes concerning depositions in those cases. So be sure to check those out. If you're a true gunner and you want homework, check those episodes out. All right, time to get into the meat and potatoes of the episode. Roger Dodd is a nationally recognized trial lawyer with offices in Georgia, Florida, and Utah. He has practiced for decades in personal injury, wrongful death, criminal defense, and family law, and has taught trial advocacy to lawyers and judges in all 50 states and internationally, and most recently in Colombia, South America, and he'll talk about that in a second. Roger, welcome back to the show. How are you defining cross-examination? Because one person's cross-examination is another person's awesome direct.
Yeah, it's interesting. Rick Friedman and I were talking on the phone literally today. His cross style is very loose and kind of rambles around and takes a lot of chances. But as you know, he does it brilliantly. He gets verdicts one after the other, and he definitely has his own style. The reason we were talking, we're doing a cross-examination seminar in Colombia, South America, of all places, because they want to change the way they cross. And my style is let's stay in control. Let's stay in tighter control. Let's do the testifying. The witness is only to say yes, and we move on. But look, you have to have a style, and you have to have a system that works for you. Mine is very controlled because I think most trials are lost, not won. And so I want to be under control that I can control. Voir dire, for instance, you can't control that. That thing's all over the place. And you better get used to that, because if you don't let it ramble and go sideways, you're not finding the right jurors. So the things I can't control, like cross, I want to control.
So let's and that makes a lot of sense. Control is the name of the game. But I guess my question though for you is why would that be a good strategy for you at deposition?
Well, let's look at the stats. When I started practicing law, literally 50 years ago, about 25% of the cases went to a jury. It was not unusual for us to not settle a case till we struck a jury and looked at the panel and said, okay, that looks pretty good for plaintiffs, or it doesn't. That affected the value of the case. Now the statistics, generous statistics, 1% of cases going to a jury. Don't waste. I'm saving it for trial. I'm saving it for trial. That's 1 penny out of $1. That's not enough to save. You have to get in there. You have to pin them down. You have to go ahead and do your cross for two reasons. The first is get the admissions you can get. I know you like to talk about, I get bullet points, then I can apply it, and you do it wonderfully. I want to get those bullet points, but I also want to show the other side your witness is not going to survive. I'm going to tear them up today. You go home and try to fix that. Now, if you fix it, you're giving me two versions, not one. I think I'm going to bet on me on that situation. Okay.
That is, I feel like the largest pushback that I get when I tell people that I follow the Roger Dodd method at deposition is, well, you're just giving the person an opportunity to cure whatever defect they had in their testimony. But that's the perfect response, is like, then I'm going to get, then I have two different witnesses. I've got right. So, oh, okay. Well, this is, if this is how you want to say it now, I locked you in at depo, right? So, okay. So I understand the idea then is that the chances of us going to trial are slim. So you want to get your hits in while you can. And even if you do go to trial, it's even if they cure, it's probably not a true cure. What about the attorney? And this was me for a long time. Well, I don't really need to know the case. I can just go into a deposition and ask why, what next, why, what next, why, what next for the 7 hours in Georgia. And that'll do me. What would you say to that person about why they should think about preparing for the deposition as a cross-examination rather than a quote unquote fact discovery deposition?
Inefficient. That's the word I give to lawyers who tell me that that's what they're going to do. Inefficient and outdated. 20 years ago, we all did a form of that. I was already getting away from that because I didn't have enough time to tell me everything you know about this case kind of deposition. We're plaintiff's lawyers. We're not billed by the hour. If you want to be the insurance defense guy, sure, do that deposition, bill your 7 hours, go home, be miserable. And, that's life. We have to be more creative. And what that means is we create more information per hour than the other side does. We have to do that. If we don't do that, we're not getting verdicts. So I'm not in favor of inefficient depositions. Are there times? Yeah, there's times. I mean, we just did a military court martial. They have limited discovery. The judge, I thought, was very restrictive with that, and I get why. He was going to protect his guy. And so we had to do, at trial, we had to do some open-ended stuff. I was not happy with that.
I was going to ask, just like literally, like, how did that make you, it made you kind of like shake a little bit to ask an open-ended question at trial?
Well, in a perfect world, it works perfectly. We're not in a perfect world. We're just not. And so, when we knew we were going to have to do it, I had two other lawyers with me. We had three defendants. They said, you want us to go first? We know this isn't your style. You can listen to mine and we'll go from there. Very reasonable analysis. But my choice was I'll go first. I'll get them talking. I'll hear a spontaneous loop. I'll give it back to them. then you all are going to have more to work with later on. And that worked out just fine. It, if you ask my druthers, I'd rather not do that. But,
Right.
if we're not flexible, then we need to get out of the courtroom.
Hey, folks, I just want to interrupt this program for the nursing home regulation question of the week. I know that's not how we normally do things on the Justice for Residents podcast, but I wanted to kind of shake things up a little bit by moving the question a little bit down into the episode so we can start the interview faster. I feel like, to the 6 people that watch the dirty half dozen, half of you drop off after the first 20 seconds. So I think that might be because I'm not getting into the interview fast enough. Who knows? Or you hate my guts. Either way, I'm moving the question to the interview. Nursing home regulation question of the week. Difficulty level, I'm going to say this week is medium. If you get this right, you get to match any 2 colors. Any 2 colors. You want to wear navy blue and black or brown and black together? It's okay. It matches. It looks good on you. It looks good on you. If anybody says anything funny about it, you tell them that I said that you could do it. All right. That's only if you get it right. So here we go. Under 42 CFR 483.21A1I, a baseline care plan does not have to be completed if A, a comprehensive care plan is developed within 48 hours of admission, B, a comprehensive care plan is developed within 72 hours of admission, or C, the resident declines to have a care plan. And that answer is A. A baseline care plan is not required if a comprehensive care plan is developed within 48 hours after admission. I feel like, at least in my experience, an advantage to treating the depo as a cross-examination is that it forces the preparation. So me as a younger lawyer, where I came in like, I don't know the case, I'm going to learn about the case at the deposition, I could go in without any prep because I'm learning as I'm asking the questions. Yeah. With the cross-examination deposition, I have already constructed the case. I have to think about themes. I have to think about, exactly, the how I'm going to use certain vocabulary. All that is already in the can before I get there. I'm not saying that I don't learn things at the deposition, sure, but man, like I went from no prep to like I'll take a week if it's an important deposition. A full week to prep. Yeah. Absolutely.
Well, listen, Rob, you're learning better if you're already prepared. You know your documents, you know the language, you know the themes you want to give. Now you're listening to any response into that matrix. You're already putting it into a system. And at least for me, it frees me up to be very creative with my word choices. I don't know why, but just recently we had a witness in deposition who said she believed in acupuncture. And that was fine. I don't know that it gets into trial, but I said, so you pay someone to intentionally stab you. Now, that opened up the door for her to say all kinds of things about how prejudiced I was and what have you and what have you. But it was all in our theme. It was all moving in our direction because I was listening with our theme in mind.
Right. That makes sense. You get to try out themes. Like maybe you have more than one vocab that you want to use. I know. And it's strange. I thought about you as I was doing this at a deposition for me a couple months ago, where I do I think it's called constructive cross. And I'm sorry, my brain is slipping, where I have the deponent, exactly, right, who is a nurse teach me what's the document is. Like if it's a care plan, like so on the left panel, this is the risk area. Yes. On the middle panel is and so that, if there's any issue, she as the deponent has already instructed the jury. So that's definitely something that I love to do. But I was going to ask you, kind of in your mind at deposition, are you trying to set up exhibits that you would use at trial? Like, in other words, like, are you creating exhibits at deposition?
Yeah, the answer to both those questions is yes and yes. We are trying to make sure that we're going to get documents in, demonstratives in, physical evidence in. We go through the authentication process. We go through the foundation process. So at trial, we already know that's in. We don't have to worry about that. Or even more important, we know we have a problem there. We're really going to have to be on our game to get it in. And as far as creating, yeah, I love even Zoom depositions. I love having a blank page and let's start creating the scene. Let's figure out where the chair was in relationship to the door.
Do you
All of
ever
that.
do you ever get pushback on that? Like, so every once in a while, I'll have attorneys. They'll say, "We're not going to create exhibits at trial. I object. This is not the point of today." Like, how do you react to that pushback?
Uh, the answer is if you're instructing them not to do it, then you instruct them to do it. We're going to then take a pause, ask the judge to rule on this because this is testimony. Demonstrative evidence, by definition, is that evidence that helps the jury, the fact finder, understand the testimony. I'm just asking him to explain it better. That's all. And if it takes a drawing, then it takes a drawing. Takes photograph, takes photograph.
And if I understand you correctly, at least from the last podcast, you, unless there are certain exceptions, you are completely on board the Zoom deposition. Like there are advantages to in person, but you don't mind the Zoom. Can you talk about that a little bit?
Yeah, I don't know why I flew so many millions of miles and didn't understand Zoom. That got past me. But COVID made me learn it and it made me get better. And now I would just as soon do a Zoom deposition as anything. Now, historically, this was 30 years ago, 35 years ago. I had a judge order me to take a telephone deposition with no screen, no nothing, just verbal, because the witness was in Turkey and you could hear jet planes taking off. He was stationed in Turkey. His testimony is going to be 15 minutes. That's all. And I fussed and fussed and fussed at the judge about, I can't see his face. I can't get the nuance, blah, blah. I argued for like 30 minutes. He said, well, you're telling me everything that could go wrong, not what has gone wrong. You take the deposition, let me know how it goes. I take a deposition. We get great stuff, great stuff. We introduce it into trial, bench trial, and the judge says, okay, it's coming in. Good. We like it. Calls us both to the bench and says, Ms. Dodd, you want to re-examine your position on telephone depositions? And he's passed away now, but until he passed away, he would go to bar functions. I'd run into him. Last time I was in Atlanta, and he would tell that story to anybody who would listen about how he taught me how to take a telephone deposition.
That's amazing. Like I couldn't even imagine. Like I guess he was on a military base. Is that what you said? Like he
was stationed in the Air Force, and you literally could hear jets in the background taking off.
Wow.
And we had a little bit of difficulty with that, but the other lawyer was fair. He, when the noise got too loud, he'd say, "Wait a minute." He was fine with it. And as the judge said, we'd all do better if we just do it and quit arguing about it.
Yeah.
Just get up and do it. Well, that's an important lesson.
Yeah. And then I think, and this kind of piggybacks on what you're talking about with these Zoom depositions, is that kind of like when you have in person, you've got your papers, you can do them in any order you want to. It's like boom, like I'm marking the exhibit, but it's more freewheeling. But again, with the Zoom, a good Zoom requires a lot of preparation. Like you already have to be ready. And I think and this is what we talked about last time, that planning is essential, plans are useless. And the real education in the process is during the planning, right? You might not use that exhibit or whatever, but the fact that you got it prepared before the depo and thought about how you're going to use it, that's the battle, right?
Absolutely. And even to the extent I send them ahead of time to the court reporter or the videographer, whoever it is in charge of that, and to the opponent. And people say, you're showing them your evidence. Okay. Is the evidence going to change?
Right.
You
And
know, you,
and if they're worth their salt, I mean, they already know what the exhibits are going to be, right?
they know 90% of it. You know, I had a deposition several years ago, nice young lawyer, brand new, really, really well prepared. And he said, I thought I was prepared, but you taught me about this. And he picked one thing out that I taught him, and it was a little obscure fact. And I said, if that's all I taught you, you're going to be one hell of a lawyer.
Yeah.
The guy was prepared, and that's the key to it. That's the key to everything.
Yeah. Well,
It's not
speaking
the
of
presentation. You know, they always want to say, well, you really presented that well. Yeah, mostly I was prepared.
speaking of education, though, speaking of being prepared, can you walk us through any of what the changes are, what we can look forward to with the new edition of your book, The Science of Cross-Examination?
Yeah, I appreciate you asking that. The fourth edition was probably the last one for me. And honestly, it was a work of great love because we've been at this for so many years. I was never pleased with the third edition, the organization of it. The content's great. The way the publisher put it together, and I didn't have a big enough vote then, um, just didn't make sense, and I don't think a trial lawyer could follow it.
Mm.
The fourth edition reads the way a trial lawyer would read it. It makes sense. You say, wait a minute, I have to look this up. You have a pretty good idea where you're going right away. And
I see.
that's the real key to it. Some new concepts, new examples, but the organization, because I don't know about you, I carried into trial. I got to pull it.
Mm.
I mean, you know, and it's always on a 15-minute break. You get whatever you find in a book, you have to find 15 minutes, right?
Right. Right. Well, I could tell you that, like, again, like it's over my shoulder. Like that book, I've dog-eared it, I've tabbed it. Like, so I'm looking forward to seeing it. I'm going to get the new edition. I'm looking forward to it. I also have the other one that you did, I believe, with your son, if I'm not mistaken,
Yeah,
the cross-examination depositions. That's also a great book. I
yeah.
think that I know that you say you're done, but I think the fifth edition needs to be incorporate the depositions book. So I'm just throwing that out there. That's the fifth edition.
I appreciate that. And we are working on the next edition of the deposition book.
Okay.
We're probably 9, 10 months out from that. And we're going to add some direct chapters, direct information, because part of it is because of the South American experience. They don't have cross in certain trials in certain jurisdictions. And so what we're going to do is add in some direct. For Americans, it'd be direct. But some of the techniques that work on direct just fine.
Mm-hmm.
We just have never talked about them before because we were concentrating on a cross.
I see. I think we talked about this as we were communicating to schedule this episode, but I spent some time in a part of Colombia called Armenia. And it's a beautiful area of the country. Like it's a remote,
Yeah.
and it was such a good time. Medellin, I think, is where you said that you were going to be.
We will.
Medellin is a cool city. So it's not like it was in the 80s, apparently, from what I understand. It's a lot younger, hip, cool, artistic, not typically your life won't be threatened. So you'll have a great experience.
Yeah, we're not going south in the country. We're
Right.
we're staying north. I understand there's like a dividing line. So
Yeah.
one of my former students is leading the charge to revolutionize their cross. And so I want to be supportive, although I got to admit I'm not looking forward to the flight. But want to be supportive of what he's doing is important.
I think you got a direct flight out of Atlanta, though.
What they have me on is out of Miami.
Okay. Yeah. Okay.
And I just get stiff. It's not that I don't like flying. It's just I stiffen up. So
I hear you. Well, Mr. Dodd, I wish you safe travels on that. I think by the time this comes out, that will have already have happened. So I'm sure there are going to be a lot of better prepared Colombian advocates when this comes out. But again, thank you so much for coming on the show and sharing your knowledge with us.
Thank you, Rob.
Awesome. Well, folks, I hope you enjoyed this episode of the Justice for Residents podcast. If you have an idea for someone that you would like for me to talk to, please let me know. If you have an idea of a topic that you would like for me to talk about, let me know that as well. New episodes come out every week. This episode was recorded on May 22nd of 2026. I believe that it is slated to come out one of the first couple weeks of June. So if that actually does happen, I hope that you are having a fantastic summer wherever you may be in the world. And I hope and wish that you would leave me some feedback. Be sure to like and subscribe wherever you get your podcasts from. And with that, folks, we will see you next week. Thanks for tuning in to the Justice for Residents podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the listener and either the host or any guest. New episodes are published every Monday and are available on all your favorite podcast apps, as well as on YouTube and our website, justiceforresidents.com. Again, that's justiceforresidents.com. The Justice for Residents podcast is hosted by Rob Schenk, a trial lawyer representing victims of nursing home abuse and neglect throughout the state of Georgia. We'll see you next Monday.